Rome Statute of the International Criminal Court, Independence of the Judges. Article 40. Independence of the Judges. 1. The judges shall be independent in the performance of their functions. 2. Judges shall not engage in any activity which is likely to interfere with their judicial functions or to affect confidence in their independence. 3. Judges required to serve on a full-time basis at the seat of the court shall not engage in any other occupation of a professional nature. 4. Any question regarding the application of paragraphs 2 and 3 shall be decided by an absolute majority of the judges. Where any such question concerns an individual judge, that judge shall not take part in the decision. Article 41. Excusing and disqualification of judges. 1. The Presidency may, at the request of a judge, excuse that judge from the exercise of a function under this statute, in accordance with the rules of procedure and evidence. 2. A judge shall not participate in any case in which his or her impartiality might reasonably be doubted on any ground. A judge shall be disqualified from a case in accordance with this paragraph if, inter alia, that judge has previously been involved in any capacity in that case before the court or in a related criminal case at the national level involving the person being investigated or prosecuted. A judge shall also be disqualified on such other grounds as may be provided for in the rules of procedure and evidence. B. The prosecutor or the person being investigated or prosecuted may request the disqualification of a judge under this paragraph. C. Any question as to the disqualification of a judge shall be decided by an absolute majority of the judges. The challenged judge shall be entitled to present his or her comments on the matter, but shall not take part in the decision. Article 42. The Office of the Prosecutor. 1. The office of the prosecutor shall act independently as a separate organ of the court. It shall be responsible for receiving referrals and any substantiated information on crimes within the jurisdiction of the court, for examining them and for conducting investigations and prosecutions before the court. A member of the office shall not seek or act on instructions from any external source. 2. The office shall be headed by the prosecutor. The prosecutor shall have full authority over the management and administration of the office, including the staff, facilities, and other resources thereof. The prosecutor shall be assisted by one or more deputy prosecutors, who shall be entitled to carry out any of the acts required of the prosecutor under this statute. The prosecutor and the deputy prosecutors shall be of different nationalities. They shall serve on a full-time basis. 3. The prosecutor and the deputy prosecutors shall be persons of high moral character, be highly competent in and have extensive practical experience in the prosecution or trial of criminal cases. They shall have an excellent knowledge of and be fluent in at least one of the working languages of the court. 4. The prosecutor shall be elected by secret ballot by an absolute majority of the members of the Assembly of States Parties. The deputy prosecutors shall be elected in the same way from a list of candidates provided by the prosecutor. The prosecutor shall nominate 3 candidates for each position of deputy prosecutor to be filled, unless a shorter term is decided upon at the time of their election. The prosecutor and the deputy prosecutors shall hold office for a term of 9 years and shall not be eligible for re-election. 5. Neither the prosecutor nor a deputy prosecutor shall engage in any activity which is likely to interfere with his or her prosecutorial functions or to affect confidence in his or her independence. They shall not engage in any other occupation of a professional nature. 6. The Presidency may excuse the prosecutor or a deputy prosecutor, at his or her request, from acting in a particular case. 7. Neither the prosecutor nor a deputy prosecutor shall participate in any matter in which their impartiality might reasonably be doubted on any ground. They shall be disqualified from a case in accordance with this paragraph if, inter alia, they have previously been involved in any capacity in that case before the court or in a related criminal case at the national level involving the person being investigated or prosecuted. 8. Any question as to the disqualification of the prosecutor or a deputy prosecutor shall be decided by the appeals chamber. A. The person being investigated or prosecuted may at any time request the disqualification of the prosecutor or a deputy prosecutor on the grounds set out in this article. B. The prosecutor or the deputy prosecutor, as appropriate, shall be entitled to present his or her comments on the matter. 9. The prosecutor shall appoint advisors with legal expertise on specific issues, including, but not limited to, sexual and gender violence and violence against children. Article 43, the Registry. 1. The Registry shall be responsible for the non-judicial aspects of the administration and servicing of the court, without prejudice to the functions and powers of the prosecutor in accordance with Article 42. 2. The Registry shall be headed by the Registrar, who shall be the principal administrative officer of the court. The Registrar shall exercise his or her functions under the authority of the President of the court. 3. The Registrar and the Deputy Registrar shall be persons of high moral character, be highly competent and have an excellent knowledge of and be fluent in at least one of the working languages of the court. 4. The judges shall elect the Registrar by an absolute majority by secret ballot, taking into account any recommendation by the Assembly of States Parties. If the need arises and upon the recommendation of the Registrar, the judges shall elect, in the same manner, a Deputy Registrar. 5. The Registrar shall hold office for a term of 5 years, shall be eligible for re-election once and shall serve on a full-time basis. The Deputy Registrar shall hold office for a term of 5 years or such shorter term as may be decided upon by an absolute majority of the judges, and may be elected on the basis that the Deputy Registrar shall be called upon to serve as required. 6. The Registrar shall set up a victims and witnesses unit within the Registry. This unit shall provide, in consultation with the Office of the Prosecutor, protective measures and security arrangements, counseling and other appropriate assistance for witnesses, victims who appear before the court, and others who are at risk on account of testimony given by such witnesses. The unit shall include staff with expertise in trauma, including trauma related to crimes of sexual violence. Article 44, Staff. 1. The prosecutor and the registrar shall appoint such qualified staff as may be required to their respective offices. In the case of the prosecutor, this shall include the appointment of investigators. 2. In the employment of staff, the prosecutor and the registrar shall ensure the highest standards of efficiency, competency, and integrity, and shall have regard, mutatis mutandis, to the criteria set forth in Article 36, Paragraph 8. 3. The registrar, with the agreement of the Presidency and the prosecutor, shall propose staff regulations which include the terms and conditions upon which the staff of the court shall be appointed, remunerated and dismissed. The staff regulations shall be approved by the Assembly of States Parties. 4. The court may, in exceptional circumstances, employ the expertise of gratis personnel offered by states parties, intergovernmental organizations or non-governmental organizations to assist with the work of any of the organs of the court. The prosecutor may accept any such offer on behalf of the office of the prosecutor. Such gratis personnel shall be employed in accordance with guidelines to be established by the Assembly of States Parties. Article 45. Solemn undertaking. Before taking up their respective duties under this statute, the judges, the prosecutor, the deputy prosecutors, the registrar and the deputy registrar shall each make a solemn undertaking in open court to exercise his or her respective functions impartially and conscientiously. Article 46. Removal from office. 1. A judge, the prosecutor, a deputy prosecutor, the registrar or the deputy registrar shall be removed from office if a decision to this effect is made in accordance with paragraph 2, in cases where that person A. Is found to have committed serious misconduct or a serious breach of his or her duties under this statute, as provided for in the Rules of Procedure and Evidence, or B. Is unable to exercise the functions required by this statute. 2. A decision as to the removal from office of a judge, the prosecutor or a deputy prosecutor under paragraph 1 shall be made by the Assembly of States Parties, by secret ballot. A. In the case of a judge, by a 2/3 majority of the states parties upon a recommendation adopted by a 2/3 majority of the other judges. B. In the case of the prosecutor, by an absolute majority of the states parties. C. In the case of a deputy prosecutor, by an absolute majority of the states parties upon the recommendation of the prosecutor. 3. A decision as to the removal from office of the registrar or deputy registrar shall be made by an absolute majority of the judges. 4. A judge, prosecutor, deputy prosecutor, registrar or deputy registrar whose conduct or ability to exercise the functions of the office as required by this statute is challenged under this article shall have full opportunity to present and receive evidence and to make submissions in accordance with the Rules of Procedure and Evidence. The person in question shall not otherwise participate in the consideration of the matter.